All right, welcome everybody to Maryland Volunteer Lawyers Services expungement webinar this afternoon. This training is being recorded for posting on our website. It is going to be a Redeem Act interim report, basically taking a look at what we've seen in the expungement space since the introduction of the Redeem Act going into effect in October of 2023. Taking a look at the positive impacts that we've seen, and then really kind of taking a look at the state of expungement practice in general, some problems that still remain despite the Redeem Act, and talking about a little bit of what might be on the horizon for the future with legislation and other sorts of ideas. So I am Chris Sweeney. I manage the Workforce Development Project here at MVLS. I'm also a staff attorney. And my co-presenter is George. I'll let you introduce yourself.
Good afternoon, everybody. My name is George Townsend. I'm the Workforce Development Staff Attorney, working with Chris and the rest of the Workforce team on the Workforce Development Project.
Okay, we'll get into it.
Perfect. So to start off, we just want to go over a little bit what the Redeem Act actually does, just for anyone who may not be familiar with what the provisions of that act are. So the Redeem Act is a fairly comprehensive bill dealing primarily with wait times, but also with a few other issues related to expungement eligibility. It went into effect October 1st of 2023. So we are now, 3.5 months into enactment of the Redeem Act. And again, the primary impact that it has had has been lowering wait times for eligible convictions. As you may or may not know, to expunge a criminal charge in the state of Maryland that has resulted in a conviction, there's a wait time that a person must observe before they can file for expungement for most cases. So for eligible misdemeanors, this had previously been a 10-year wait period. The Redeem Act reduced it to 5 years, with the exception of second-degree assault and battery, both of which are misdemeanors, are now a 7-year wait. For felonies, typically the wait period had been 15 years. The Redeem Act reduced the wait time for CDS possession with intent to distribute and third-degree burglary to a 7-year wait period, slightly more than half of the previous, or slightly less than half of the previous wait period. And then for first and second-degree burglary and felony theft, the wait time is reduced from 15 years to 10 years. Other than the wait time, the same eligibility rules apply. So the waiting period begins to run with the completion of the sentence, and any subsequent conviction within the wait period will block expungement until the subsequent conviction becomes eligible, which is still a pretty significant block to a lot of people getting things expunged. But we'll talk a little bit later about how the reduction of wait times opens up a lot of additional cases because of that subsequent conviction rule. One quick last note is that there are some of these charges can be classified as domestically related, in which case they would be left at a 15-year wait period. This is primarily going to apply to second-degree assault and battery cases. Sometimes during the course of a second-degree assault or battery case, the case can become categorized as a domestic case, in which case it would be subject to the old 15 wait year period instead of the new 7-year wait period.
And just to follow up on a little bit of additional information on the Redeem Act, like George mentioned, it basically left the expungement rules that we know intact, just shortening those waiting periods. However, it did add one more misdemeanor to the list of eligible convictions. That was malicious destruction of property. So that's a misdemeanor that's going to be in that new 5-year category. That's actually a charge that we saw a lot of that would often block cases. That would be a unit rule violation. That would be a subsequent conviction violation. And it's the type of thing that often comes along with a second-degree assault or some related sort of incident where I think the reality is that the language malicious destruction sounds pretty severe, but we're seeing that people are getting charged with that sort of thing pretty frequently in cases where it was kind of a run-of-the-mill dispute with someone and not particularly horrific behavior or anything like that. So it's great that that was been added, opening up a lot of more expungement availability. The Redeem Act also added this provision that unpaid court costs are not a bar to expungement, and they shall in fact be waived when the court is granting an expungement. That was a little bit of a gray area in expungement practice for a long time, where there was no explicit provision in the statute that said fees had to be paid before expungement could take place. But a lot of courts would enforce that as a rule. There was really no uniform practice as to whether or not that was going to be treated as a bar to expungement. And now it is in the statute that it's not.
All right, so results so far, what we've seen is, as indicated in the slide, a pretty dramatic increase in the eligibility for expungement. So there's a first and sort of obvious way that the Redeem Act has increased eligibility, which is just to say that because the wait times are significantly shorter, there are a lot of people who had charges, misdemeanor charges 7 or 8 years in the past, or felony charges that are they had been 11 or 12 years ago in the past. So before the Redeem Act, they were still a few years away from their eligibility. Now that the wait times are reduced, those former defendants, are becoming eligible much sooner, which is fantastic. The other very significant impact of reducing the wait times is something we mentioned earlier called the subsequent conviction rule. So to recap that for anyone who hasn't done a lot of expungement analysis, if a person is convicted of a charge that is eligible for expungement under Criminal Procedure Rule 10.110, they obviously have a wait period that they have to go through before they are eligible for expungement. If they are convicted of a second crime within that wait period, they are not eligible for expungement of the first crime either at all or until the second crime becomes eligible for expungement, if it does so. So there's an example up here on the board of a misdemeanor theft conviction, a person who has a misdemeanor theft conviction in 2010 and 2019. So prior to the Redeem Act, there was a 10-year wait period for a misdemeanor theft conviction. If you were convicted of a misdemeanor theft in 2010 and you served the sentence, say the sentence also ends in 2010, a 10-year wait period would put you to 2020. However, if you have a subsequent conviction for a second misdemeanor theft in 2019, you cannot expunge either charge until the later one becomes eligible for expungement, which would be 2029 with another 10-year wait period. When you reduce the wait times, the 2010 case with a 5-year wait period would have become eligible in 2015 because there's no subsequent conviction within that 5-year wait period. That 2010 case automatically becomes expungible. You no longer have to wait until that later case becomes eligible. 2019 case will still be eligible 5 years after the sentence ends, which would be 2024. So that case would either be eligible now as well or would become eligible soon. But you can see how many people who are expunging criminal records have a long list of misdemeanor offenses. So even when the wait time for a particular charge was 10 years, oftentimes you see people will get charged and convicted with a misdemeanor crime, and then 4 or 5 years later, they get another one. 4 or 5 years after that, another conviction. So people have chains of subsequent convictions rendering earlier convictions ineligible, sometimes stretching back into, I've seen cases not infrequently from the 1990s that will eventually become eligible, but only after the wait time for subsequent convictions have elapsed. Reducing the wait times prevents these, it breaks up these sort of chains of subsequent convictions, allowing people to expunge their older cases much earlier. It also has the effect of if a person has a conviction that would become eligible, but then they have a subsequent conviction that is not eligible and never will be eligible for something like possession of a regulated firearm or some other offense that is not included on the list of eligible offenses, something like a robbery or something like that, reducing the wait time would potentially move that later conviction that's never going to be eligible out of the wait period of the earlier conviction, which would then let the earlier conviction be eligible for expungement. So there are a lot of cases. We've seen several MVLS clients who had previously been expungement clients. We've been sort of encouraging them to check back in with us to make sure, because some of them had cases that when we first did expungement analysis for them 5 or 10 years ago, were not eligible, but now they are, because the wait time change has rendered some of their older cases now eligible. In other effects, Maryland's wait times for expungement are now dramatically closer to the national norm. Previous to this change, Maryland was close to the worst in the country for expungement wait times. If you exclude states that don't have any expungement whatsoever, which there are only a small handful of, Maryland was the longest wait times of any state to get expungements for eligible convictions. So we're much closer to the norm nationwide with this change.
So the REDEEM Act certainly had a really positive impact on the expungement landscape and a positive impact on people who are struggling with the stigma and barriers related to living with a criminal record. And we've been really excited to see this positive direction that expungement advocacy has gone in the past several years. A lot of lawmakers are understanding why this is such a big issue. It's part of the national larger conversation about criminal justice reform in our country. But despite all of those positive effects of the REDEEM Act, there are still some pretty major problems that are getting in the way of people expunging, and even you could say kind of reducing the positive impact of the REDEEM Act. So there was an appellate decision called In Re Abhishek that was handed down a year or two ago that basically held that in many cases where someone has violated their probation, they are not going to be entitled to seek expungement for that case, even if it is eligible under the statute. There also is still this ongoing problem of the conviction expungement process being based on this long enumerated list of specific offenses that are eligible with attached waiting periods. But that list just doesn't include everything that it should include. It omits a pretty sizable number of very common misdemeanors, despite including felonies and other things that would generally be considered more serious. And that, of course, is causing subsequent conviction violations. It's causing unit rule violations. And the combination of these two things, unfortunately, you could probably say that sort of defeating the purpose of the REDEEM Act and all of the positive movement that we've seen in terms of expungement in the last couple of years. So I'll let George on the next slide explain in more detail how exactly that Abhishek decision has been working out.
Yeah, so to go over a little bit what the Abhishek decision actually, what was actually decided in that court case. Essentially, it's an interpretation of the language in the expungement eligibility statute that has the effect of essentially disqualifying expungement eligibility for any defendant who has violated probation. If there's a case that results in a sentence of probation, and then the defendant later has a violation of probation or an unsatisfactory completion of probation entered on their record, that under Abhishek renders the case entirely ineligible for expungement. So it looks at language in the expungement eligibility statute that says the time period for expungement eligibility begins at the, in quotes here, satisfactory completion of sentence. And many people are sentenced to probation, they have a violation of probation or some other situation that results in probation being closed as unsatisfactory. And the Abhishek court decision determined that when a probation is closed as unsatisfactory, it will never trigger the wait period for expungement eligibility, and therefore that case will never be eligible for expungement. There's a pretty significant problem. By some nationwide estimates, less than half of defendants on supervised probation complete that sentence without a violation. And a lot of the violations can be very technical. So something like showing up late to an appointment or not paying costs that are applied by the courts. And it's also largely, in many cases, the probation officer can have discretion in closing probation as satisfactory or unsatisfactory. So this is a pretty significant impact on the practice of expungement analysis. These are very common to see people who have some sort of violation of probation on their record. And one of the major problems is it essentially cuts that person off from receiving an expungement ever on that offense. And the problem with this is we see often cases where typically when a person is sentenced to probation rather than incarceration, it's typically an acknowledgement that is a less serious offense. It's a way for a person to sort of be reincorporated into their community without the sort of very traumatic and arduous punishment of being incarcerated. So when a person is sentenced to probation and then they have a violation, and that takes that case that otherwise would have become eligible and renders it ineligible, oftentimes people are left in the position of almost wishing that they had been incarcerated instead, because if they had been sentenced to a jail term, they would have completed that term in usually a couple months, maybe a year, and then become eligible for expungement 5, 7, or 10 years after the sentence ended. Typically also, when a person if they violated probation, they typically are sentenced to some alternative jail term. In the actual Abhishek case that the court decided, the person was on 1 year probation. They violated probation by possessing cannabis, which was illegal at that time. And then so they were instead, probation was closed and they were sentenced to a very short jail term, I believe 4 days. If they had just been sentenced to jail to begin with, then once they completed that term, they would have triggered the wait period for expungement eligibility. Because they were instead sentenced to probation and technically did not satisfy probation, they never became eligible for expungement. So this is creating a lot of problems for a lot of people, and all turning on just the use of a single word in this expungement statute that is having a lot of downstream effects on individuals.
As we mentioned before, in addition to the Abhishek ruling, we have for a long time been seeing this issue crop up where there are a number of mostly very minor offenses, mostly misdemeanors, that are simply missing from the list found in Criminal Procedure 10-110 that lists out all of the possible offenses where if someone's convicted are possibly eligible for expungement. So instead of setting up a situation where the statute just says all misdemeanors are eligible after 5 years and maybe pulling out a few particularly egregious things and saying those can't be expunged, it does the opposite, where it just tries to find all of these minor offenses, but inevitably you're going to miss a lot because there are things like local codes and nuisance crimes that are kind of cataloged differently and they were just missed, etc. One of the biggest things is there were originally no transportation article violations included whatsoever. That was blocking a lot of people from getting expungement, because driving on a suspended license, driving without a license, are extremely common. And with MVLS clients, we see those two convictions very often because they are pretty often the result of inability to pay fines, fees, etc., and someone losing their license. So it is definitely wrapped up in the criminalization of poverty. Suspended license has been added to the eligibility list, but driving without a license has not. So someone getting driving without a license conviction, that's going to count as a subsequent conviction, just as the same as if they were convicted of some violent act like armed robbery that's not eligible. So in a sense, you could say that driving without a license and armed robbery or something even worse are equivalents according to the expungement statute, because neither is ever allowed to be expunged. There's also just an assortment of nuisance crimes and behaviors that are codified under local ordinances that count as subsequent convictions. So there is a sort of section of the expungement framework that allows for this expungement of nuisance crimes and does actually kind of provide for categories of behaviors and even local codes. But it gives specific categories like loitering or open container, and it omits others. So we've seen all sorts of things like someone being given a citation for sleeping in a park, someone being given a citation for driving, or I mean, rather riding a bike on a sidewalk. I've actually even seen someone who had a conviction for spitting on the sidewalk. These are all sorts of these little nuisance crimes that they're not specifically enumerated in the statute. Therefore, if someone is found guilty, that is going to be counted against them as a subsequent conviction. And some of that silly stuff that I mentioned, unfortunately, our attitude would be that this is definitely wrapped up in the racial injustice that we see in our criminal legal system, with people of color being more likely to be stopped by police, being more likely to get arrested and charged with the crime after a police stop, and even see harsher sentencing when compared to white people. Another big one is failure to obey a reasonable lawful order or resisting arrest. That neither of these can be expunged if found guilty. And resisting arrest maybe doesn't fall into the lowest of the low category, like sleeping in a park, in terms of severity of crimes. But these are two charges that we see really frequently that are blocking up expungement. And we see instances very often where someone is charged with maybe 3 or 4 counts in a case, and all of the charges get dropped except for resisting arrest. And now this person is convicted of resisting arrest when they were actually never convicted of the actual crime they were arrested for in the first place, which certainly seems pretty illogical. And anecdotally, it's hard not to feel like, seeing this so often, that those charges are kind of slapped on when they just need to convict somebody of something, and the state doesn't end up actually convicting them of theft or whatever it was, but they get that on their record and now it's permanent and it can never be expunged. So to illustrate how this statutory framework produces illogical results, we have 2 examples of 2 different people and what could be on a client's record. And this is very much in line with the clients that we see at MVLS. So if person A is convicted 3 different times in 3 completely separate incidents over several years, all felonies. So felony theft, first-degree burglary, almost 10 years later, drug possession with intent to distribute, 6 years after that. These are 3 felonies that are allowed to be expunged if the other requirements are met, which would again be no subsequent conviction and waiting period has passed. So if someone served their time and waited long enough for that 2020 conviction to pass the waiting period, then all three of those felonies would become eligible as the current statute is written. If person B was convicted of a misdemeanor, theft in 2000, it could be something as simple as stealing a candy bar from Royal Farms or something. And then 4 years later was convicted of driving without a license. The driving without a license is ineligible, and it is a subsequent conviction that blocks the 2000 case. That means both of these misdemeanor offenses are never eligible for expungement. So the way the statutory framework is set up could certainly stand to be improved. A lot of advocates have been pushing for a sort of blanket eligibility for misdemeanors. And like I mentioned earlier, if something is particularly egregious that happens to be a misdemeanor, it could be singled out as not eligible. But we certainly need more of a catch-all sort of eligibility when it comes to misdemeanors. Another thing that advocates have pointed out as an option would be to allow for expungement of any crime where the defendant is not entitled to a jury trial. That would hopefully catch all of these minor things like sleeping in a park and all these little citations that are not eligible because they've fallen through the cracks of the current statutory framework.
Perfect. So the last thing we wanted to go over today was just sort of a review of some of the current legislation that's being debated as we speak in the Maryland General Assembly. Some of these are bills that we are sort of actively monitoring and have provided testimony about. But many of the activists in the expungement space are watching these particular bills and are hoping that they might resolve some of the problems we've identified today. One sort of the very simple one would be a fix to the Abhishek decision that we discussed earlier in the presentation. It essentially just changes the language in the eligibility statute, removing the word satisfactory from the language about the completion of the sentence, and clarifying that the wait period for eligibility begins at the conclusion of court-mandated supervision. So if a person has probation and that probation ends, whether it's satisfactorily or unsatisfactorily, that would trigger the beginning of the wait time for eligibility for that offense. And it, of course, keeps the same wait periods in effect. So a person is still not going to be able to violate probation and then immediately file for expungement. They still have to wait for the, first of all, any subsequent sentence that they get as a result of the violation, and then also the 5 or 7 or 10-year wait period. Another bill that's currently has been filed is a bill that would create good cause expungement, essentially allowing expungement of cases that are not listed in the criminal procedure article 110, or for early expungement of a otherwise eligible case that just would be expunged early if there is good cause. There is already a good cause provision in the separate expungement statute for non-conviction cases. So null prosequis, stats, dismissals, acquittals, those already have a good cause provision for filing those cases early. And this would merely sort of expand good cause eligibility to conviction cases under certain circumstances. And there's a few others. There's one that would allow former defendants to expunge certain cases out of a unit. So if a person was charged with multiple crimes, it would allow them to expunge the ones that are eligible while leaving in place the charges that were ineligible.
So we'll be monitoring, of course, all of these expungement bills and probably doing a legislative wrap-up in the spring. We hope to have good news to report on the expungement side of things. and MVLS has been supporting some of those bills and testifying as part of that effort. So that's all we have today for the presentation. Thank you to everyone who joined us. I'm checking the chat and Q&A to see if there are any questions. I'm not seeing anything right now. We'll wait maybe a second to see if anyone does want to type a question in. But if you are a volunteer joining us, expungement is a really great way to get started volunteering, or maybe get back into volunteering if you haven't in a while. It's a pretty low time commitment sort of case. You can check out our website that's listed on the slide. We have a pro bono portal that lists clients who are actively seeking to be matched with a volunteer. It can be sorted by case type, and you can click on a case and just click accept if that's something you'd like to do. And our website also contains all sorts of additional training materials like this one, pre-recorded videos, as well as slides and flowcharts and flyers and all sorts of stuff to help you out with learning or refreshing on expungement. So I don't see any questions coming in right now. Our email addresses are on the screen. If you ever do want to reach out with any sort of expungement related inquiry, we are happy to assist. So with that, thank you all very much for watching, and hope you enjoy the rest of your day.